Hello and welcome to episode 106 of Not Reserving Judgment, a podcast about the latest intrigues, triumphs, and outrages in Canadian constitutional law. I'm Josh DeHaas, counsel with the Canadian Constitution Foundation.
I'm Christine Van Geyn, the CCS litigation director.
And I'm Joanna Barron, the CCF's executive director. And in today's episode, I'll tell you about a shocking letter that residents of Richmond, BC received after that huge court decision that found Aboriginal title to their properties.
And I'll tell you what's going on with the Mark Carney government's proposed tough on crime legislation.
And we'll share our bad legal takes of the week, where we take a lighthearted look at some legal opinions that didn't quite land. But first, I'm going to talk to you about Bill C-9, which is the proposed new hate speech law that Christine talked about last month when it first landed. And I'm going to try and answer a question that I keep getting asked, which is, would C-9 really mean that you can be arrested for posting offensive online memes? And the short answer, disturbingly, is yes, it could. So the reason I'm talking about this is because of a viral exchange that people keep sending me between Conservative MP Andrew Lawton and Attorney General Sean Fraser that took place in a parliamentary committee that's studying C9. And you'll recall from Christine's excellent summary that this is the new federal bill that would make it a crime to promote hatred using terrorist or Nazi symbols, would create a new statutory definition of hatred that's lower than the one currently in the case law, would remove the requirement for Attorney General consent for hate speech charges, and would create new crimes of intimidation and obstruction outside of sensitive places like churches and schools. So in committee, Lawton asks Fraser, C9 makes reference to public spaces. Does that include the internet? After a long pause, Minister Fraser responds, generally speaking, the law will apply equally online as in real communities, but just in the limited circumstances where there is willful promotion of hatred. So could this include online memes? And the answer is clearly yes. So here's why. Canada has long had hate speech laws, Section 319 of the Criminal Code, which forbids public incitement of hatred and willful promotion of hatred. And there's also Section 318, which is against advocating genocide. And as of 2022, willful promotion of anti-Semitism was added to the list. And as listeners know, there was also a push to add residential school denialism to Section 319. So as a free speech advocate, it won't surprise you that I don't support any of these laws. Mere speech should never be criminalized, whether it's online or in person, because that means the government gets to decide what you say, and it defeats the whole purpose of freedom of speech. Only where speech takes, harmful physical form or poses a real threat of imminent violence, for example, saying, let's go to that place and burn down that person's house, is where the state can and should step in. So I don't think we should have these kinds of laws, but the saving grace for 319 historically was how it's been used, which is quite rarely, and that's for three different reasons. So one of the reasons it's not used a lot is because police need to get consent from a provincial attorney general before laying the charges, which attorneys general are reluctant to do because it's politically controversial to arrest people for their words, as it should be. Also, second, the Supreme Court's appeared to set a relatively high bar for what counts as hatred. This comes from the 1990 case Keegstra and clarified in the 2014 decision Watcott, where the court has said that hatred is limited to those extreme manifestations of the emotion described by the words detestation and vilification. And then the third reason that these charges have been historically rare is provincial attorneys general have been reluctant to find that speech on social media is taking place in public and not in a private conversation, which are requirements for 319. And this is because our hate speech laws, they predate the internet, and they exempted speech made in private conversations, for example, inside two people speaking inside someone's house. And so it's genuinely debatable whether posting on an internet site like X or Facebook is captured by those words and is communication in a public place and not in private conversation, unlike, handing out flyers in the street or saying something at a political rally. Okay, so enter Bill C-9. As we've mentioned, this would remove the requirement for AG consent. And if police can lay charges directly, it's not unreasonable to expect that they're going to do that. And I say this because many police forces in Canada already have dedicated hate crimes units in place, and they can't necessarily do a lot without AG consent. If the bill passes, they would be able to, and they're going to face huge pressure from groups like B'nai B'rith, the National Council of Canadian Muslims, and Canadian Anti-Hate Network to lay more hate speech charges. We can also look at Britain, where there are similar hate speech charges in place that more obviously apply to online speech, and they get used all the time. So, for example, last summer there were false rumors spreading that the man who had stabbed 13 girls in Southport, England, was a migrant. He wasn't, but many people thought he was. And many people ended up jailed simply for their social media posts about it. For example, there was a man named Lee Dunn who went to jail for 8 weeks for sharing racially aggravated anti-immigration memes on Facebook. There was a man named Billy Thompson who was sent to jail for 12 weeks for a Facebook post that included emojis of a person of ethnic minority with a gun. And most famously, Lucy Conley, who got 31 months for writing mass deportation now, set fire to the hotels for all I care. While you're at it, take the treacherous government politicians with them. I feel physically sick knowing these families will now have to endure. And if that makes me a racist, so be it. So notably, Conley didn't actually say we should go set fires to the hotel. She didn't call for that type of violence. And yet she still got 3 years in prison for what was merely very offensive and to some people hurtful speech. She was imprisoned under the Public Order Act, which forbids threatening, abusive, or insulting words, or displaying any written material which is threatening, abusive, or insulting, and that is likely to stir up racial hatred. Bottom line, these charges are not rare in the UK. So the Times reports that police made 12,000 arrests in 2023, which was up 58% from 2019 under just two of Britain's hate speech laws. So, 1,000 plus per month and going up all the time. And so if we remove AG consent, that could lead to more charges for online speech here in Canada. So the second thing C-9 does that would lead to potentially to charges for your online memes is that it would create this statutory definition of hatred that is lower than what the Supreme Court has ordered in those cases I mentioned, where the court emphasized that hatred is an extreme emotion and in some places uses the word extreme in their definition. So by leaving that out and just saying, what the bill would say, which is that hatred is the emotion that involves detestation or vilification and that is stronger than disdain or dislike, it's going to lead to more charges. For example, if all that's required is mere vilification or detestation, then think about the X posts that led to the arrest of Graham Linehan, the comedian at Heathrow Airport last month. One of those posts that got him arrested was an aerial shot of a group of transgender rights protesters with the words, "A photo you can smell." And, while that may be offensive and it's not a very funny joke, I don't think that should lead to criminal charges or an investigation, yet it did lead to an investigation which was eventually dropped. Under a mere detestation or vilification standard, I could see Canadian police making an arrest for that type of speech or joke posted on X. And then this all comes at a time when attorneys generals have started to rip the Band-Aid and consider social media expressions to be happening in a public place or not in private conversation, and laying 319 charges already. So this is a trend that started in Quebec, where there have been a few convictions. And then this summer it spread to Ontario, where a North Bay man was convicted and sentenced to 9 months in jail, plus 2 years of probation for his anti-Semitic Facebook posts. It's also spread to Manitoba, where there's a man who faces charges for allegedly hateful anti-LGBT posts on X. So the short answer is that people are already getting arrested in Canada for their social media so-called hate speech. And with a lower statutory definition proposed, plus the removal of AG consent, I think we would see a lot more charges and possibly convictions for simply posting memes that other people find Offensive. So I'm very worried about this, Christine. I know you're worried about it too. You've written about this in National Post. Do you want to tell us a bit about that piece and the response you've had to that?
Yeah, so I wrote a kind of sort of funny news hook from the National Post, which is that this is sort of all about Mark Carney's fetishization of the UK. We all know that he loves the UK. He kind of famously has this insistence on British spelling, which I'll actually comment on in my news segment as well. That anyone in the PMO needs to use British spelling, and we kind of use in Canada a mixture. Like we mostly use British spelling, but sometimes use American spelling. He has these dress codes for the PMO where men need to wear black shoes, which is really a very formal rule from England,
I
from the
actually had
city.
never heard about no brown in town, so
Oh
thank you for
yeah,
enlightening me.
yeah. Well, I mean, it only applies to men, so we're immune. Uh, and I think that he does look sort of aspirationally to the UK to inspire a lot of these things. And actually, I read that the UK is now walking back some of these things that they're doing. The non-crime hate incidents that has been causing so much consternation, not just for people in the UK who get police knocking on their door because they posted a meme about the prime minister, or two girls got in a fight on Snapchat and they have the police knocking on their door. Uh, and the police record these as non-crime hate incidents, which go on a record that certain employers would have access to. I have heard that they are walking all of this back. That the police do not want to have to do this. It's a big burden on the police. I'm sure there are certain officers who do want to do it, but for the most part, my understanding is they do not want this responsibility. So,
Christine,
I
they're not going to record anymore, but they might still show up, and the laws are all still in place. So
is that
it's
what's
progress.
happening? So
Yeah,
I
at the
just read a
minute. So
headline.
it won't be recorded anymore, and that non-hate crime incident thing was that's takes it to a whole new level. But yeah, the laws are all still there, but it is definitely progress.
It they should just stop doing this entirely. I just don't understand the mentality that if someone posts something mean online, you're going to call the police. That's completely insane to me and completely inconsistent with a liberal democracy. Like it gives me really bad kind of Stasi vibes where the police keep this list of what everyone thinks that could be used against them in the future that has really, really been abused by totalitarian regimes in the past. I just don't understand why England wanted to embrace an approach like that. And I don't know what it is that makes Carney look at that longingly. So I have a big problem with most of what's in C-9, and I really am pushing hard for this bill to not be passed. Joanna, what do you think?
Yeah, I agree. It's insidious. In some ways, I was asked about this by some students at a student event I was at on Friday. And in some ways, originally it was a relief because we were expecting a federal bubble zones law. But in many ways, it's more insidious. And especially hearing what the Liberal Department of Justice has to say about it, it's clear that either they have thought through the ramifications and this is what they want, or they haven't thought them through at all. And I go back and forth. But anyways, do you want to tell us about your headline, Christine?
Yeah, sure. So I want to talk about this announcement Mark Carney made about his new plan to combat crime in Canada. And a lot of aspects of this plan might sound familiar to some Canadians. So, uh, look, a lot of people have concerns about crime rates in Canada, violent crime, bail, sort of the revolving door of people getting out on bail when they're repeat offenders. A lot of people have concerns about sentences being too lenient in Canada. This has been a campaign issue for about a year, and the Conservatives pushed hard on this. The Liberals have kind of taken it up and are running with it, and honestly, good for them. Because I agree that this is a problem, and I'm happy to see a Liberal government actually wants to do something about it. And I'm going to tell you what the proposal is. So Carney announced a pretty wide-ranging plan to deal with crime. The legislation has not been released yet. So, what I'm going to tell you is based on what Carney has said at a high level and what happened in the press conference and what is on the Prime Minister's office website. So, first, Carney says he's going to introduce a reverse onus for bail for quote major crimes. The Prime Minister's office doesn't say what major crimes are, but in the press conference, they clarified that these were repeat offenders who've been charged with home invasions, violent car thefts, assault, sexual assault, extortion, or human trafficking. And they're proposing a reverse onus, which would be different from what the current system has, where prosecutors have to prove that denying bail is justified for those crimes. The second change is allowing what is often referred to as consecutive sentencing. So that means multiple crimes mean longer times behind bars. I'm going to get into why this is a bit of a misnomer, but it's kind of easy shorthand. The third proposal is imposing harsher penalties for organized retail theft. And they spelled organized with an S, not a Z. I usually spell it with a Z, the American way, but British spelling in the PMO. And the fourth requirement is restricting conditional sentences for a number of different sexual offenses. So I'm going to be focusing today on the second proposal, which is the consecutive sentences. Now, I said this might sound familiar because we actually had some of this already, and the court struck it down. In particular, in 2011, the Harper government had introduced a provision of the Criminal Code, Section 745.51, that was aimed at ensuring people convicted of multiple murders served longer sentences before they were eligible for parole. So I said it's a bit of a misnomer to call it consecutive sentences. It's actually the stacking of parole ineligibility. But I mean, in practice, it has the same effect. So before the Harper law, a person convicted of first-degree murder would receive life in prison with no parole for 25 years, even if the person had killed multiple victims, like in a mass shooting. In that case, parole ineligibility, whether you shot one person or six people, was still capped at 25 years. Now, of course, there's always the possibility that parole would be denied, keeping them in jail indefinitely, but they would be eligible for parole at 25 years. Now, Harper wanted to change that. So he introduced this new provision, 745.51, that allowed judges to stack the parole ineligibility periods. That meant someone could effectively be sentenced to spend the rest of their natural life in prison without any possibility of parole, a de facto life without parole sentence. So if you shot, three people, you could have 25, 25, 25 as your parole ineligibility. So you're not eligible for parole for 75 years. Now, this scenario played out in the Supreme Court case involving mass murderer Alexandre Bissonnette. He was the Quebec City mosque shooter, and he murdered 6 men in a mass shooting at a mosque in 2017. And he was given life imprisonment, and his parole ineligibility was stacked under that Harper era law. So even though he killed 6 people, they didn't stack 25 years 6 times. The judge gave him ineligibility for 40 years. So it was still discounted. Now, Bissonnette appealed this sentence, arguing that this would likely be the remainder of his natural life and that this violated the charter, particularly Section 12 of the charter, the protection against cruel and unusual punishment. And quite famously, the Supreme Court agreed. They said that this would be cruel and unusual punishment, as is prohibited by Section 12 of the Charter. They held that stacked parole ineligibility can exceed life expectancy of any person, and it deprives offenders of any realistic possibility of rehabilitation, no matter how genuine their remorse or change. And that this type of punishment undermines human dignity and therefore cannot be justified in a free and democratic society. And that decision was unanimous. It was a 9-0 decision from the Supreme Court. There was and continues to be a lot of outrage about the Bissonnette decision. And during the federal election campaign earlier this year, conservative leader Pierre Poilievre promised to restore these types of sentences. Um, as I said, they're called these consecutive sentences. Pierre called them consecutive sentences. Carney calls them consecutive sentences, but they're actually the stacking of parole and eligibility. And Pierre said he wanted to bring them back, but he acknowledged that the Supreme Court had ruled these sentences unconstitutional. So he promised to bring them back using Section 33 of the Charter, the notwithstanding clause. Now, the notwithstanding clause has never been used federally. And as you can imagine, people went apoplectic. The media was absolutely hysterical that Pierre Poilievre wanted to, quote, end the rule of law in Canada. And obviously, I do think we should be skeptical of uses of the notwithstanding clause, but the whole idea of it is that the legislature gets the final word on the interpretation of rights. And there was a pretty widespread belief among the public that the court had overstepped in their interpretation of rights in the Bissonnette decision. Now, that was what Poilievre suggested. Carney is suggesting essentially the same thing, although he has not said that they would use a notwithstanding clause. And it has been, completely consistent with Canadian media's approach to things that when a liberal proposes something that a conservative also proposed, they're outraged by the conservative proposal and completely tolerant of the liberal exact same version of the same thing. So there has not been outrage that Mark Carney is attempting to undermine the rule of law by reintroducing these consecutive sentences. He was asked at the press conference how he expects this proposal to pass a constitutional test since this exact thing was ruled unconstitutional in Bissonnette. And Carney responded by saying his government has met with constitutional experts, police forces, and justice ministers from across the country to ensure the legislation is viable. And he said, this is a package that we expect. It does what it's supposed to do. It toughens the rules, punish criminals. It will keep us safe, but it is also consistent with the charter. I literally don't know what that means, but I suppose when it is introduced, we will see the details of the legislation and how they plan to pass this. I just do not know what it means that it is a package that makes the law consistent with the charter. But honestly, I hope that Carney is successful. I would love to see something like this in Canadian law. I think that the vast majority of Canadians agree that the Bissonnette decision is outrageous. Many people feel like the Supreme Court got it wrong. And you know what? I even have this feeling that courts, like the media, might just be more amenable to a law introduced by the Liberals than an identical law introduced by conservatives, which obviously should not be the case. But maybe that is what will happen. But what I think we can rule out is the use of the notwithstanding clause. I know that the Carney government, they just filed this factum in the Supreme Court case of Hack. That's the Bill 21 case out of Quebec about religious symbols. And in that factum, they argue for pretty significant restraints on the availability of Section 33, the notwithstanding clause. So I would be floored if using the notwithstanding clause is part of their plan, but I guess we're going to have to wait and see. Josh, how do you think the Carney government is actually going to make this constitutional when we know that it was struck down in the Harper version of the law?
I'm really not sure. I think one possibility is that they'll do something weird where for very serious crimes, this is not going to be allowed, and for somewhat less serious crimes, it would, because I think that the Supreme Court might uphold it as long as your sentence is not, more than 40 years or something like that. But
I mean, the Bissonnette was a serious crime. It was murder.
yeah, that's the most serious crime is murder of six people, I believe, if I'm getting that correct.
Yeah.
I don't know. So I've been
Motivated by hate and Islamophobia, which is
Yeah,
definitely an aggravating factor. Yeah.
it is.
Yeah, it's as bad as it gets. But I'm saying I think that consecutive sentences, the court might allow them as long as you're not going over a certain number of years. So we'd be in this weird situation where murderers can't get really long sentences, but
I mean, 40
car
years isn't
thieves or
even that
something
long for
could.
killing 6 people.
Yeah, it's pretty outrageous. This is a really interesting point you make about this government because they're liberals and liberals are tend to be viewed as soft on crime, getting maybe getting away with this sort of tough on crime legislation, whereas conservatives would not. The media would just hound them. And another example of that is the reverse onus thing that you mentioned. You know, a lot of libertarians say that this violates Section 11E of the Charter, which says you have the right to not be denied reasonable bail without just cause, and putting the onus on the offender is an unusual thing to do. Now, the courts have upheld that kind of surprisingly. They've said, they've said reverse onuses can be legal in some circumstances, but the devil's in the details. So I wouldn't be surprised to see pushback and also some legal challenges. But just on the question of like what we should actually do about these people, I saw an interesting interview on CBC the other day. And in British Columbia, they have a program where they identify repeat offenders and then they essentially give them a label and say this is someone that's, their file, like here's their file. They've been charged, dozens or hundreds of times. And you should really not let them out, judge. And then that's available for the Crown to like, pull up. And apparently that's quite successful. And judges that see that sort of designation will not grant bail. So that's interesting. The other thing that this guy said, and he was a Crown in BC, was that they still don't know if somebody's been charged with crimes in other provinces a lot of the times. Like they don't have access to that information if it's outside of their own province. So you can have people that have fled to BC and they have long records, and the Crowns can't get that in time for the bail hearing. So there's a lot of just like basic sort of database type things that we could be doing before we introduce new laws, and it's kind of unfortunate that we don't do that stuff first, because these things can impact people's rights. Joanna, what do you think of this? Are you hopeful that this will solve the problem? What are you thinking?
Well, what I'm curious to see is how they're going to try and pitch this so that it will be upheld by a court. I mean, I guess we can take the cynical view that the court will just see it differently if it's not Pierre Poilievre or a conservative government. But I'm curious to see if they're going to try and dress up the same substance as Poilievre was proposing, but in procedural clothing. Like they could introduce some type of review mechanism that nominally preserves some realistic possibility of parole, but it's pushed out long enough that it also satisfies the public appetite for tougher sentences. So they could allow judges to impose consecutive ineligibility periods subject to a mandatory judicial review after, let's say, 35 years. And that could be framed as some sort of safety valve. And maybe that would allow the government to argue that the law is still in compliance of Bissonnette. But maybe they won't even go that far. So this is really interesting development, and talks a lot about sort of like the constitutional politics in this country, and how they appear differently depending on who the speaker is, who the proposer is, I should say. So let's take a break and then we will come back to this Cowichan mess. Okay, so this week, homeowners in Richmond, BC, opened their mail to find a fairly shocking letter. This is a warning from City Hall that a recent court ruling could negatively affect title to their properties. This is not hyperbole or clickbait. This is an actual municipal advisory. The case, of course, is Cowichan Tribes versus Canada, which came out in August, and Josh discussed extensively a couple of months back on the podcast. And if it stands, it could shake the foundations of how property rights work in this country. And this is one sort of early signaler. So, just to recap, on August 7th, the BC Supreme Court recognized Aboriginal title over a portion of Richmond, and the court affirmed a constitutionally protected fishing right. The court also said that historical crown grants and interests over that land were defective. They suspended this declaration for 18 months to allow governments and the Cowichan to make arrangements and, I suppose, negotiations about how exactly this was going to be sorted out. Now, the Attorney General of BC is appealing and has also sought a stay, and the province has warned of significant unintended consequences for fee simple owners. Now, I just watched a great interview on Hub Hits with Dwight Newman, who is Canada Research Chair and one of the leading experts in this area. And his quick take was, if you own land in Richmond, particularly in the specified areas, you should be concerned. He says that Richmond's letter, of course, doesn't add any new law. It simply distills on a practical level the implications of the August ruling. The court is not ordering transfers of private homes. The immediate legal effects targets federal and city lands, and aspects of that are being stayed on appeal anyways. However, Dwight Newman says that the decision creates new risk factors for private titles that simply didn't exist in the same way before. He also notes that the plaintiff said they don't intend to displace ordinary homeowners, but that's not legally binding and could be subject to change and interpretation over time. So homeowners are effectively being asked to trust future choices by now determined rights holders pending appellate clarification. So, why is this happening in BC first? It's important. This is a bit of a nuance that probably a lot of people aren't aware of. I don't think I was fully aware of. Most of BC is not covered by historic treaties, so overlapping title claims like this are quite widespread. He explains that on proof, the court's test can recognize seasonal occupation, where exclusivity at the time of sovereignty, which here is 1846, is shown. And this is sometimes shown via fairly grim historic evidence of how others stayed away. He also flags intra-Indigenous disputes, for example, between the Musqueam and the Tsawwassen, that are now part of the appeals as well. So this case is very complex, and higher court clarity is really essential. Now, this could be system level destabilizing. Tom Isaac, who is a leading Indigenous law practitioner in Vancouver, has called the ruling fundamentally upending to BC's land title system. And he highlights two stark implications. First, that Aboriginal title can be declared atop private property. And second, that courts could order transfer to First Nations after such a declaration, which would create a sort of Damocles hanging over fee simple. And he says, tell that to the bank. If fee simple is no longer the unquestioned pinnacle of security, mortgages, lending, valuations, and market confidence are all really fundamentally thrown into play. So here's the unresolved tension that the appellate courts must answer. First, some practitioners argue that Aboriginal title burdens fee simple, and the two can coexist in principle until they conflict at one point, and at which point, obviously, one has to give way, right? Reconciliation requires a framework. Who decides what compensatory rules apply, how to rank uses? And others, including Tom Isaac, warned that the ruling effectively is prioritizing Aboriginal title over fee simple, which really erodes certainty, which is the keystone of our entire land title and mortgage system. And Newman's caution really dovetails here that even with a stay on government-held parcels in Richmond, the judgment alters the risk calculus on private portions of land within the claim owner and claim area and beyond, because it signals what could happen if title is pressed against private estates later. And of course, courts are not operating in a vacuum here. The land back rhetoric, the ubiquitous land acknowledgements are really creating a cultural backdrop that is pressing for these bolder judicial remedies. So this didn't come out of nowhere. This case is really a watershed because it's moving a fairly abstract, amorphous conversation into concrete consequences. Mortgages, fee simple, inheritances, municipal planning, capital markets. So what would the practical consequences of this be if it was upheld? Tighten lending in claim zones, price discounts, if the very stability of your claim is in question, presumably your property value is going to take a nosedive. transactional friction. And this is not because reconciliation is wrong, but it's because certainty is really the asset that underscores property markets. Tom Isaac's perspective is that reconciliation has to compensate historic injustices, which no doubt exist, without undermining something as fundamental as private ownership. Now, the province says it prefers negotiation to avoid unintended consequences. But as Dwight Newman pointed out, the negotiations tend to stall when parties disagree on the background law, which is precisely why this probably needs to go to the Supreme Court of Canada and ASAP to set nationally reliable rules. So, Josh, Christine, maybe I'll start with you. I know that you've been looking into this extensively, and we actually had the opportunity to chat with Tom Isaac a couple of weeks ago. Were you surprised when you saw the kind of rubber hitting the road with this Richmond letter?
I mean, I think that the government in Richmond did this to really draw attention to what's happening. I think that, I mean, Richmond obviously was opposed. They opposed this in the litigation. And I think a lot of people were not really paying attention because it was a long case, right? It went on, I think the trial itself went on for 500 days. And so people kind of had maybe tuned out. And Richmond, by sending this letter, which went absolutely viral on social media, I mean, I saw American influencers, like conservative influencers, reposting this. And I mean, the letter is shocking. It includes the maps of the land that would be affected. And it says, you know, if your land is in the black area, your title is essentially unsettled now. And I, I look, I've looked through the decision. I actually interviewed Tom Isaac and Dwight Newman together on my show a week ago, Canadian Justice. That episode should be out either this week or next week. And the decision just is wild. You know, fee simple private property ownership is the strongest title that you can have. And now people who have that do not know if there is simultaneously somehow, and I don't know how these two things can exist simultaneously. I don't think that they can. They don't know if there is Aboriginal title on their fee simple property. And that just completely upends the relationship between fee simple private property ownership and Aboriginal title. It throws everything into question. So this is obviously getting appealed. We're tracking this. I think we have a lot of interest in intervening in the appeal to clarify the law about fee simple ownership and how Aboriginal title actually gets established. Because I do not think what happened in this case is the correct way to establish title or to sort of think about the relationship between these types of title. Josh, what do you think?
I think the decision is pretty crazy, to be honest. You know, this is based on Section 35 of the Constitution Act 1982, which says that existing rights, it recognizes and affirms existing rights. In 1982, when people were agreeing to that Constitution, did anyone think that you know, Aboriginal title still existed in places where fee simple had been granted and guaranteed by the province? Like that's what land titles is all about. That's the basis of our entire society, economic and otherwise, is property ownership and the government recognizing that. So apparently, according to the court, they've said that no, that Aboriginal title wasn't extinguished by you know, granting land to other people, even though that's what everyone would have thought back in 1982. So that leaves us in this crazy situation. And I got into a little argument with Terry Glavin on Twitter about this the other day, or X, I should say. And he's a journalist that I have huge respect for, like great guy, fascinating work. But totally disagree with him here. He tweeted about how these letters had been sent out by Richmond and said, I'm bored of the fatuous news like this. Everybody has known for at least half a century that unextinguished Aboriginal title underlies private property wherever no treaties have been concluded. And that's just not true. Like I don't think anybody thought that or thinks that. There's a test for Aboriginal title, and it's hard to meet, or at least it was very hard to meet before this Cowichan case. Has a requirement of exclusivity. Like if you want to say you own land, you have to be able to keep other people out of it, which is not the case in most of British Columbia. There has to be, continuity between the pre-sovereignty declaration and present time. This idea that all land in British Columbia was owned by Indigenous people. Well, that suggests that they were using or had some claim to property rights over all of that land, and that can't possibly be true on any theory of property. So it just doesn't make sense. But what's clear is that this particular decision has unsettled everything, and it's very bad for business and for reconciliation, and it needs to be addressed really quickly by the courts. So that's all I want to say about that. Maybe we will. Did we already take our break?
Yeah,
No.
we did.
Oh, we did. Okay. So let's move on to our bad legal takes then. Christine, do you want to go first?
Sure. So my bad legal take this week is related to the Alberta teachers strike. So the strike has been going on for 3 weeks now. It's really disrupting people's lives, as these teacher strikes do. They always create a lot of political pressure on the government. And the Alberta government is now saying they may introduce back to work legislation next week if the strike remains unresolved. So the minister in charge, Joseph Shao, said, "We are going to take whatever steps are needed to make sure that kids are in the classroom and get an education they need to be successful going forward." So this is interpreted to mean there could be back to work legislation. Now, you may recall that when Doug Ford in Ontario was faced with a pretty intractable education worker strike in 2022, which was at the tail end of the pandemic. So it was really a bad time for the strike to take place in Ontario because kids had already been out of school for a really long time. So that was happening. Doug Ford moved to introduce back to work legislation, and they passed a bill called Bill 28, Keeping Students in Class Act. And that imposed a collective agreement on education support workers. Now, critically, the government invoked Section 33 of the Charter, the notwithstanding clause, in order to uh, push this forward because certain charter protected rights, like freedom of association, most relevantly, would be affected by back to work legislation. So they put Section 33 into the bill so that the law could not easily be challenged under the charter. Now, people in Ontario went nuts, or by people, I mean a lot of education workers went nuts. And under pressure, the government agreed in Ontario to repeal Bill 28 shortly after it was introduced, before this imposed contract could take effect. And so this dispute was ended up being averted by a new deal that they ended up reaching. So there's an argument that it was used as a negotiating tactic in Ontario. Now, there's a lot of speculation in Alberta now that if Smith introduces this back to work legislation that's kind of being floated, it might also involve the use of Section 33. The Minister Shao, was asked specifically about this and wouldn't comment. But as a result of all of this, there's, of course, a lot of hysteria online about the potential of back to work legislation, the potential of the use of the notwithstanding clause. And there was a long thread on X from a user that I'm going to talk about now. The user's name is Skip is Chris. And this user said the Alberta government is now openly floating the use of the notwithstanding clause. That actually isn't happening. The government has not said, they just haven't commented on it. And Skip It Chris said, you all need to be expletive mad as hell right now. This isn't a negotiation tactic. It's a constitutional crisis in the making. Skip is Chris goes on to say, because this wouldn't just be unprecedented in Alberta, it would be the first time in Canadian history that a government used Section 33 to silence a labor group in the middle of bargaining, which of course isn't true. I mean, I literally just gave you the example of the time that Ford did it But you know what? I will give Skip's Chris the benefit of the doubt because Ford did walk it back like he does with most things. Um, Now, look, I don't want to be too hard on this user because even though I do not think that these statements are entirely accurate, for example, Skip is Chris also said, if you believe in democracy, this is your line in the sand. And I mean, the purpose of the notwithstanding clause is to give power to the legislature on the final determination of rights. It's a democratic tool. But um, what I would like to say is this. Uh, Public anger, like this user is showing, is actually what is necessary as part of the democratic process when Section 33 is either floated or used. Uh, this user's hysterical reaction is actually part of the way the system is supposed to work. It's intended, this public reaction is part of what constrains the use of the notwithstanding clause by legislatures. So I guess good, go and be angry because that is how democracy works in the context of this particular part of our Constitution. But a few BLTs in there for this user for, not historically accurate. It is a democratic tool. And I also don't think that the government has said that they are planning to do this. So a few BLTs, but you know what? It's justified because that's how democracy works. And I believe in democracy. Joanna, what's your BLT this week?
So my bad legal take goes to Morgan Ogre, who is scheduled to be participating in an event this week, to be meant to be held this week. We'll be watching to see if it goes ahead. I think it's scheduled for tomorrow. So, Heterodox Academy, which is an organization that promotes viewpoint diversity that we're friendly with, is planning an event at Wilfrid Laurier University. It's a dialogue on gender identity, evidence, and impacts. So, clearly a flashpoint issue. But before it even began, one of the interlocutors, an activist named Morgan Ogre, warned her fellow participant, Mia Hughes, who I take it is more gender critical. I don't know if that's the right term, but anyway, she's more of a TERF. I take it. And by the way, I have never heard of either of these people, so I don't really have any priors about them. But anyways, Morgan warned Mia that some of her views could constitute hate speech under the criminal code. So first, bad legal take to Morgan. It's not how the law or intellectual inquiry works. First of all, Canada's hate speech provisions, in spite of today's hand-wringing, are exceptionally narrow and certainly would not encompass even a spicy, controversial debate. They prohibit the willful public incitement of hatred against an unidentifiable group in circumstances likely to lead to violence or disorder. Robust debate on gender policy, even if it's controversial, even if it offends people, especially so, doesn't come close. And posturing otherwise misstates the law and weaponizes fear. Second, Augur's warning wasn't invitation to dialogue, it was a veiled threat. Preemptively invoking legal processes turns the university, which is meant to be an open marketplace of ideas, into a minefield. It's saying, speak carefully or we might come for you later. Now, I'm not even sure why Morgan Ogre, if this is how she sees the nature of a debate at a university, why she would accept an invitation from Heterodox Academy. This is their whole raison d'etre. Now, to their credit, the Heterodox Academy organizers responded with a participation agreement, which is a document requiring both speakers to accept that offensive ideas may be expressed, to forego legal complaints based on words spoken in good faith. And I think this is a helpful framing of the, interpretive dimensions of the debate. It's a strong attempt to protect academic freedom and restore a zone of open inquiry, but it does seem like the train has already left the station. And when you're going into an event where one of your participants is openly implying, reading between the lines, that some people may be attending for the express purpose of filing human rights or hate speech complaints. I would say that the whole purpose of open dialogue and maximum, free inquiry about controversial issues that we have to work out. We have to work at universities. We have to work out as a society. They're clearly divisive. I think clearly you're not on board with that foundational premise. So I'm not going to tell the HXA, the Heterodox Academy organizers, what to do. But my condolences to them that they have to deal with this. And bad legal take on the law to Morgan. Josh, what's your bad legal take?
My bad legal take goes to a teacher near Barrie, Ontario, that shall remain nameless because it happens to be at the school that my niece attends. It also happens to be her teacher, even though this happened in a previous year. So this old tweet has resurfaced on X, and it's getting a lot of attention because it's not only outrageously political for a grade six teacher to be teaching this, but it's also very blatantly legally false. So this tweet says our 6-7 class rewrote the land acknowledgement in their own words with words that had meaning to them. It says, we are guests on the shared traditional and stolen lands of the Anishinaabe people. We protect the land by planting trees and gardens, picking up litter, recycling, and using less plastic, oil, gas, and electricity. We promise to treat the land and the people who live on it with kindness and respect. And it goes on, but no one can debate that this is a bad legal take because it's just not true. It's one thing to do a land acknowledgement where you recognize that this was the traditional territory and that, Indigenous people still live in that particular area and all of that. I don't know if I'm on board with doing it every single day at the beginning of the school day, along with O Canada as they do in the Toronto District School Board, but it's not particularly offensive to say that you're on traditional territories or lands of an Indigenous people. But what happened with this teacher near Barrie is just factually incorrect. So that particular land is not stolen. It was purchased in treaty from the Anishinaabe people in what's called the Lake Simcoe Purchase, which is a treaty that is non-controversial. It happened in 1815 and it's perfectly legally binding. So someone needs to educate this teacher who is apparently misleading children in that school. All right, that's the end of the show. So as usual, we thank you for listening, and we hope that if you haven't already, you will rate us, review, and subscribe, and tell your friends about the podcast. And you can also support our work by subscribing to the CCF's YouTube channel, by following us on X, and by visiting our website, theccf.ca, where you can sign up for our Freedom Update newsletter. The CCF is a nonpartisan legal charity funded by your donations, so please do donate on our website if you can. Thanks for listening.
Okay, thanks, guys. I guess my mic held up.
Yeah, the
So,
recording stopped, right? Or
yes.
okay.
Oh, wait, no, it didn't. Sorry.